So if you haven't picked up a book, pick one up up front, because we will be going over the consent decree requirements. And then we'll be talking about a lot of, most of the laws that are outlined as violations that occurred. So we will be going over Section 504 of the Rehabilitation Act. The Americans with Disability Acts are most commonly referred to as ADA. The Fair Housing Act, and then fair housing protections under the Fair Housing Act, and how that directly impacts persons with disabilities. We will be discussing reasonable accommodations and reasonable modifications and how you make those, what you can request, what you can't request when verifying a person's disability, what classifies as a disability under the Fair Housing Act. And then we'll be talking about fair housing in zoning and different land use, how we apply ordinances, and then we'll end with some better practices and affirmatively furthering fair housing, how we can make sure that we're meeting all of the suggestions mandated and mandates and requirements set forth by the Department of Justice, and how we can make sure that you guys are continuously being proactive and addressing these concerns and these issues in your community. So we're going to start off with zoning ordinances. I do ask that if you guys, I will stop after each topic to kind of see if anybody has questions. If you do have questions, please stop me in the middle. Just, the kindergarten thing, raise your hand. We'll make sure to stop. We've had some pretty good discussions in our other sessions. We had a couple sessions yesterday. I do ask that you keep it to the laws and regulations. Because getting into hypotheticals, I am not your legal counsel, I am not your attorney, and so I suggest that any very specific or hypotheticals that you have in mind, you discuss amongst yourself and with your legal counsel, or you run it by the DOJ. Okay? So the consent decree, as Vanessa was stating, this consent decree was initiated after it was found that the City of Jackson violated the Fair Housing Act. So it was found that the City of Jackson not only violated the Fair Housing Act, but also violated the Americans with Disabilities Act, Title II specifically, and which meant they were discriminating on the basis of disability by excluding persons in recovery from alcohol or substance abuse from living in specific homes that were zoned in particular residential areas. So what happened is the city enforced the discriminatory zoning ordinance in practice, and against that homeowner, and the person with disabilities resulted in not being able to have housing and not being allowed to have individuals that were suffering from a disability and recovering reside in the home. Ultimately, the consent decree is voluntarily agreed upon, not only by the City of Jackson, but the DOJ. So this was an agreement that both parties came to in order to resolve the matter. Most of these requirements have been completed. This consent decree came down and was signed and filed in June, like at the end of June. And most of the requirements were said to be completed within 30 to 90 days. They had different deadlines, but most of them were 30 days, 60 days, 90 days. So most of these have already completed. Were already completed. The first one is going to be at the bottom of page 3. That's where we're going to start seeing the requirements of the city. If you go down to specific injunctive relief at the bottom of page 3, you'll see that the first requirement is to stop enforcing the definition of group home for the handicapped. As it's found in zoning ordinances section 20267 and 20269, right? Because that prohibits persons in recovery from addiction to alcohol or a controlled substance from residing in the home. So making sure that you're changing that definition. So the zoning ordinance section actually prohibited, I'm going to turn off this light because it's hard to see. So I'm just going to turn off the one in the front. It's hard to see the slides that way. So this prohibits persons in recovery from addiction to alcohol or substance abuse from residing in these homes. This also, with this amendment, it will also remove the city requirement by definition that requires that homes for persons with disabilities have staff members and have caregivers. So that removes that requirement from the zoning ordinance that was outlined in the consent decree. And it really ensures that persons in recovery and persons with disabilities are permitted to reside in homes at in all residential zones and in all residential locations, that they're provided equal access to housing. The consent decree also eliminates the 1,000-foot spacing requirement that was applied to homes for persons with disabilities, including persons in recovery. So there no longer should be the 1,000-foot requirement enforcement of individuals with one home. So saying, one home does not have to be 1,000 feet away from the next home for persons with disabilities. The city of Jackson is not allowed to modify the zoning ordinance or enact any future ordinance in a manner that narrows, reduces, or limits the rights of persons with disabilities to reside in the residence of their choosing, right? So passing any new legislation or any new laws is not permitted under the consent decree. The decree outlines the city's need to propose a written policy that provides a process for individuals to submit fair housing complaints, reasonable accommodation requests, and then also to designate a fair housing compliance officer, and also to receive fair housing ADA training, which is why we're conducting this training. So as far as the consent decree requirements, is anybody confused about the requirements moving forward? About what zoning ordinances were changed? Okay. So we're going to talk a little bit about the laws and how the laws apply. Section 504 of the Rehabilitation Act was the first disability civil rights law to be enacted in the United States. It prohibits discrimination against people with disability in programs that receive federal financial assistance. So that means all the programs that are governed through your city or county government is covered by Section 504. This really set the stage for the ADA, or the Americans with Disabilities Act, in order to work together. The one big difference that you'll see in the ADA and Section 504 is Section 504 is specific to federal financial assistance, while Section 2 or Title 2 of the ADA covers private entities as well. So the ADA is going to be for private, public programs. So you don't actually have to receive federal financial assistance for the ADA to apply. This works together with the ADA to protect children and adults with disabilities from exclusion. This is not only in housing, it is in schools, jobs, and the community. The Americans with Disabilities Act does work with Section 504 in prohibiting discrimination against individuals with disabilities in all areas of public life. On January 1st, 2009, there was an amendment to the ADA, and that amendment not only changed the definition of disability to be more inclusive, it provided examples of what a more inclusive definition would be. So what was happening is the Supreme Court was seeing a lot of cases where individuals that may not have a readily apparent disability, may have mental disabilities, or may have a disability that isn't occurring and is sporadic, like epilepsy, or a mental disability like someone being bipolar or someone suffering from a substance abuse. What they wanted to do is they wanted to make sure that these laws protected those individuals too, and it was a more inclusive and farther reaching definition of what constituted an individual that was disabled. Right, so we'll talk about under the Fair Housing Act what that definition is. It's anybody who suffers from a physical or mental impairment that substantially limits one or more of their major life activities. We will talk further in the presentation about what you can and can't request to actually verify this disability, and who can attest to these disabilities and who's able to actually provide the proof of the person suffering from the disability. The ADA is divided into 5 titles or sections. Title 1 covers employment. Title 2 covers state and local government, so non-discrimination on the basis of disability in state and local government services. Title 2 was actually what the violation was under when the DOJ filed. It was Title 2 of the ADA. Title 3 covers public accommodations, so non-discrimination on the basis of disability by public accommodations and in commercial facilities. And then Title 4 covers telecommunications, so your auxiliary aides, your first responders, those kinds of things. And then Title V covers miscellaneous provisions. So Title II regulation. Title II regulation covers public entities, so that includes any state or local government and any of its departments, agencies, and other institutions, right? Vanessa talked about how it impacts everybody. It's down to the operator that picks up the phone and takes the 911 call, right? So it trickles down and everybody's held accountable. It covers all activities, services, and programs of public entities. So any state legislators, courts, town meetings, police and fire departments, DMV, right, motor vehicle licensing, and it extends to all activities of state and local governments, whether or not they use federal funds. So that's really important because people get confused about Section 504 and ADA. Yes, Section 504 only applies if you receive federal funds. We see a lot of the times, especially in in counties with more resources, they'll deny federal funds just to be like, well, we don't have to, we just don't want to have to deal with all of this compliance. We don't want to deal with all this compliance. We're going to stop taking federal funds. Unfortunately, that's not the case with Title II. Title II, it's not only programs that are administered through federal funds. So if you receive private funds, it covers those as well. Any questions on Title II? We're going to talk about the requirements next. So what are the requirements of Title II? Cannot refuse to allow a person with a disability to participate in a service, program, or activity simply because of the person's disability, right? You must provide programs and services in an integrated setting, and we'll talk about the importance of integration around persons with disabilities. And you must eliminate unnecessary eligibility standards or rules that may deny individuals with disabilities an equal opportunity to enjoy the services. Making reasonable modifications and accommodation in rules, practices, and procedures. So changing things so that they're able to adapt and change to meet the needs of those persons with disabilities. We will talk about when you can deny accommodation, a reasonable accommodation, because we do understand that there's also strains on funding. There's also strains on what could change your program in its entirety, right? And we don't want to do that. We want to make sure that the accommodations that we're making are reasonable. And reasonable is a subjective term, right? So like what I think is reasonable isn't reasonable to somebody else. Everybody has different thresholds of what they're willing to give in different situations. So there is a threshold of kind of where the courts see it as to what constitutes a valid denial and what doesn't. And then also furnishing auxiliary aids and services when necessary to make sure there's effective communication. Unless it's an undue burden or fundamental alteration of the program would result, and providing special benefits beyond those required by the regulation. I tell everybody when I'm training, like, be good humans, like the world needs better humans, because what really we need to do is not look to be proactive and not look to address things when they become issues or when somebody files a fair housing complaint. As you were talking about with occupancy standards, does it only, what if somebody files a fair housing complaint? You don't want to get to the point where somebody is that upset or they've been impacted in such a way where they feel the need to bring a complaint and they feel that their civil rights have been violated. You want to make sure that you are being proactive and consistently making sure that there are special accommodations in place that go above and beyond just like the standard, right? Or just like the benchmark to be like, okay, check, we did, we have 5% of these auxiliary aids, we're compliant by law, right? You want to make sure that you go above and beyond. Important, no special charges can be placed on individuals that may need these disabilities. That is the entity and the program's responsibility to cover these costs for the individual in order to make sure that they have access to the programs. And then also making sure that you operate programs so that when it's viewed in its entirety, that the program is accessible to and usable by persons with disabilities. Any questions on requirements? No? Okay. It's a quieter group than yesterday. So Title II program access. Program access ensures that individuals with disabilities are not excluded, are not completely excluded from services and programs, making sure there's no physical barriers. So a lot of the times, especially in a lot of rural counties or cities, even in metropolitan areas, right? There's really old buildings. I live in Washington, D.C. I think my building was built in like 1930, 1940, where my apartment is. But these buildings are old, right? So making sure that even though they're older buildings, they're retrofitted or there is access to the individuals to get into the building, making sure there's access for the individuals to engage with staff in order to benefit from the different programs. So for example, if you're not able to put in an elevator, right, and there's 2 stories or 3 stories, you're not able to put in an elevator for access, what are the programs that persons with disabilities are using, right? What are those programs? Making sure they're on the floor. Maybe having a specific conference room or a specific just small room where the individual can come down when they have an appointment to make sure that they're there for the person who has a disability, a mobility impairment or any type of disability, to make sure that they're on the first floor when they arrive and they can access those services, right? So making sure that you're making those accommodations. Now, no requirement can fundamentally alter the nature of the service. The best example I have is waiting list, right? So waiting list for PHAs or public housing authorities, Section 8 programs. Those requirements, the waiting list is a waiting list that people are on for years sometimes. Vouchers are consistently declining in the amount that are given to different cities and counties. Those programs are funds are consistently being removed. So if somebody with disability says, I would like to be put at the top of the list, I want the first available apartment, that fundamentally alters your program in the sense of there are other people that may have a disability that just haven't requested it, or there are other people that have been waiting longer. But so that may be unreasonable, right? Because it fundamentally alters your program. However, what wouldn't would be them saying, well, I would like to be the first, if an accessible unit becomes available, I want to be on the list first to receive the accessible unit, right? Because you don't know if the accessible unit is going, even if you choose the top person on the waiting list, you don't know if an accessible unit is going to come, going to be available the next time that person is at the top of the list. That's reasonable because there is limited amount of accessible units. Importance of integration. Integration of individuals with disabilities into the mainstream of society is fundamental. Public entities may not provide services or benefits to individuals with disabilities through programs that are separate or different. We want to make sure that they feel inclusive. Individuals with a disability have the ultimate right to decide to deny any type of program that is being integrated, or if they're benefiting from some integration of a program, they do have the right to deny it. However, it must be given up and it must be their choice, right? And then they have the ability to accept or deny a accommodation. So say there's a reasonable accommodation that is requested, and we'll talk about what that is, but if there's a reasonable accommodation that is requested and the housing provider or the employer or the city official has a different accommodation that would work, that they feel is more reasonable, and they provide that in exchange for the other unreasonable accommodation, the individual can deny it. The individual does have that right. They're not forced to take any accommodation that's provided to them. So communication. So under the ADA, individuals must provide auxiliary aids for individuals with hearing, vision, or speech impairments. And these could be interpreters, assisted listening headsets, And we don't mean the interpreters that, has anybody watched the news where any people are just saying they can speak American Sign Language and then they're on the screen and it's like not American Sign Language? My brother is deaf and mute, so we always laugh at them. So making sure that those interpreters are certified, that you are providing the individual with the ability to have a certified interpreter, so not always saying, oh, can you get a spouse or a family member to come in with you, right? Not inconveniencing them in that manner, but providing certified interpreters to translate. And then public entities cannot charge an individual for these services if they have a disability. And also telephone emergency services, including 911 services. Most 911 emergency first responders do have, at a minimum, the TTY relay. If you don't, you're out of compliance, but that is sufficient for, in regards to like first responders, 911 services, just having a TTY service for individuals with hearing impairments. Title II, new construction and alterations. Buildings and facilities must be free of architectural and communication barriers that restrict access. We'll see all the time where there's a ramp, right? So there's a ramp outside, there's a ramp that you're able to get into the building, and there's actually no sidewalk from that ramp to the parking lot. So I don't know how people expect someone in a wheelchair to get from there to the ramp without a sidewalk, or the sidewalk is covered with different like potholes. It's actually not paved. There is a huge tree where the individual wouldn't be able to go under. So thinking of those things and keeping in mind and considering that even though you're meeting the checklist of requirements, like is it when the practice is held out, does it actually make sense, and are you actually meeting the needs, or does it actually constitute a civil rights violation, even if you're going through your checklist, right? Because I'm sure the individuals that went through this consent decree went through their checklist in regards to, okay, well, the zoning ordinance says this, check, right? So making sure that even though you know the laws and regulations, when the practice is carried out, how does that impact individuals? Ensuring alterations to existing buildings are accessible. So again, talking about those older buildings, everyone does renovations. Everybody loves doing renovations to make sure their property values go up, or they're able to incentivize new developers, incentivize different people to invest and bring their business to the area. However, is it actually accessible when you're making those changes, right? We don't want it just to look pretty. We want it to actually be accessible to persons with disabilities. Does anybody have any questions on the ADA? No? All right, so we're going to talk about the Fair Housing Act. I'm going to show a quick video about how the Fair Housing Act came to pass, how we got to the Fair Housing Act. It'll be 50 years that we have the Fair Housing Act come April. So I'm going to find that. So as you see in the video, there are 7 protected classes. So the Fair Housing Act prohibits discrimination in sale, rental, financing of a home or dwelling based on 7 protected classes. We didn't always have 7 protected classes. When it was first passed, we had 4. Can anybody guess what those 4 were? Race? Religion? National origin? Not gender. Ethnicity is national origin. Not gender. Color. Right? So we had race, color, national origin, religion. We only had 4 protected classes when the Fair Housing Act was first passed 50 years ago. In 1974, we added gender and sex. We actually did not add familial status or disability and handicap until 1988, which isn't that long ago, right? So it took us a while to get to where we're adding familial status and disability and handicap. Now, since then, you'll find that there are additional protected classes based on local ordinances, based on state laws that do expand protections. For example, in DC, I believe we have a total of 22 protected classes down to personal appearance, political affiliation. We have a ton. That matriculation, I think, is one, creed, ancestry. All of these things are included under our protected classes in the District of Columbia, right? But federally, HUD actually provides a ton of rules and regulations for guidance when it comes to federally funded or federal assistance programs. And the HUD Equal Access Rule 5662 covers sexual orientation or gender identity. And then we also have the Violence Against Women Act that was passed in 2013. So that has to do when a lot of the times we will see, whether it be with homeowners associations or rental properties, there will be some form of domestic DV event, some form of domestic violence, and the individual is arrested, right? So then there's criminal activity at the property, at the home. And what happens the next day is somebody receives a letter on their door with an eviction notice, right? Or with a 7-day notice with no opportunity to cure, therefore losing their home because of something that happened and they're actually the victim. So that's what was put in place for women and actually survivors. So I have used VAWA to protect males from similar situations. So I'm not saying that it only happens to women and women are only the victims. Does happen across the aisles. So there are state laws and local ordinances that can expand them. I am actually not familiar with City of Jackson or State of Mississippi having any extra ones, from my understanding. That doesn't mean that they're not needed, right? So if you're continuously seeing that people are making allegations based on gender identity or discrimination based on sexual orientation, maybe that's something that you need to push forward in regards to including those protections locally, right? Because your local government can actually provide those protections. Any questions on the protected classes? All right, so what are the prohibited practices, right? Can anybody think of things that are prohibited? Hint, there's some in this consent decree. Anybody? Refusal to sell or rent. It's on the screen. Refusal to sell or rent. Discrimination in the terms and conditions. So what does that mean? That means charging a higher security deposit, charging a higher interest rate on loans, those kinds of things. To make, print, or publish, so anything that is advertised that states that there's any type of limitation or that may be perceived as there's a limitation. A lot of the times you'll see these ads, right? And they're like, it's like this beautiful Caucasian, very like homogenous group of people. We have seen ads like that go through because it may not be deliberately discriminating, but you're implying that you're renting or creating communities for only certain individuals. So making sure that your advertisement is being inclusive, those kinds of things. Also, discrimination in residential real estate transaction. Anybody heard of redlining, steering, right? So what happens is loan officers, lending institutes draw a huge red line and make sure they don't provide loans to those areas. Most of the time those areas are minorities, and we will watch a video on that as well. So I'm going to show a video on redlining, how we got to redlining, just because it's a good video on understanding kind of how our practices continuously impact generations to come, right? And we can't actually get out of it, and that goes for practices that are instituted now. A lot of the times when we think of Fair Housing Act discrimination, things that are violating people's civil rights, we stick to race, and sometimes that's the easiest way to understand it, right, is race or national origin. But really it means that if you're enacting laws, like it's going to have a trickle down, and like it's going to have a longer lasting impact if you're passing those laws now in the future. So I think this video does a good job in showing how that happened with the redlining. All right, so we're going to get started with talking about disability under the Fair Housing Act. So Fair Housing Act defines disability as individuals with a physical or mental impairment that substantially limits one or more major life activities. So waking up in the morning, going to work, dressing yourself, anything like that. Individuals who are, the second part is individuals who are regarded as having such an impairment. So individuals that may not have been diagnosed, but they're considered or regarded as having such an impairment, or individuals with a record of such impairment. Major life activities that are essential to the importance of daily life. And disability does include drug addiction, right? We talked about that. Other than addiction caused by current illegal use of a controlled substance, right? Current illegal use of a controlled substance. And also alcoholism. Any questions on disabilities definition? We'll talk about what you can and cannot ask for later. Okay. So what are prohibited practices? They're going to be the exact same as Section 804, refusal to sell or rent, discrimination in the terms and conditions, so setting forth different terms and conditions because of a person's disability. Also, refusal to permit at the expense of the handicapped person reasonable modifications. So we will go over what reasonable modifications are, and or refusal to make a reasonable accommodation. So reasonable accommodation in the rules, practices, policies, or procedures. So what's a reasonable modification? Reasonable modification is an alteration to the physical premise, allowing a person with a disability to overcome obstacles that interfere with his or her use of the dwelling. Examples, installation of a ramp. I always think of modification as to modify, so it's actually going to be a change in a physical structure. Modifications are at the expense of the person requesting it, unless it is to a government building or if it is to any type of public area. Then it is then the expense must be covered by that entity or that organization or business, right? But as far as modifications within a dwelling, within the home, that is the responsibility of the individual. Any questions on reasonable modifications? Reasonable accommodations. This is actually one of the violations outlined in the consent decree, was a refusal and a failure to make an accommodation. And I believe the accommodation was to allow more than one home within the 1,000 feet ordinance that used to be enacted. So what was requested, if I'm right, is that that they be allowed to have two homes within the 1,000 feet, exempt of that rule, right? That was not allowed, therefore it was a refusal. An accommodation is a change to the rules, policies, practices, or procedures. Another example of that would be asking for a parking space, right? A lot of the times we'll see that either businesses, organizations, or housing providers state that they can't provide, that they have handicap parking. So, you know, what's the need or the use for a designated parking space? However, if that person requests it as a reasonable accommodation, it doesn't matter how many parking spaces you have to comply. Right? We see a lot of the times currently we have a lot of cases around emotional support animals and no pet policies or the type of emotional support animal. It doesn't matter if it's a miniature horse, if it is a monkey, if it's a crocodile, alligator. We had a case in Florida where it was an alligator. You have to actually allow the support animal. I'm serious. Yeah. Yes. Yes. So what happened was, I'd like to tell this story because it was, I mean, when we first took on the case at Legal Services, everybody was like, "You're crazy." I mean, that's a direct harm. It's a direct threat. And the reason that the individual was being asked to get rid of her service animal, which was the alligator, was because there was a rule by the Department of Wildlife that any type of alligator up to a certain amount had to be on 10 acres of land, and she only had 5, right? So it had grown to the point where there was an actual regulation, there was a law in place that the Department of Wildlife states, no, the alligator has to be on more than 10 acres, right? But federal, I see you in the back. Federal law, the Federal Fair Housing Act trumps any type of like local law, right? So the federal law actually states that if the person requests an accommodation, they have to oblige, right? So they have to say yes. So the person submitted it to the Department of Wildlife and said, okay, I want you to provide an exemption to this rule because I only have 5 acres and this is my emotional support animal. This alligator, she would put like leather jackets on. She would put him on a motorcycle, and she actually started dressing him and started caring for him after her son had passed away at war. So after her son had passed away in Iraq, she all of a sudden had this alligator come up onto her property, and she cared from him from that moment. So it had provided her emotional support since that time. Now, a lot of people are like, I don't want to live next to an alligator, right? I'm not trying to like get killed, but it did not. Because she had 5 acres of land, there wasn't any direct harm around. And I say that because with the consent decree, a lot of people stated that they didn't feel safe, or they felt like there was a harm to them. There has to be a direct harm in order to deny the accommodation, right? It can't be based on stereotypes and generalizations that somebody may or may not do something that is going to harm you, right? So a direct threat is someone saying, I'm going to harm you in XYZ kind of way, right? Not just, oh, I see this person, they look kind of suspicious, and they're probably going to harm me, they're probably going to rob me. It's the same reason why people clutch their bags when they're around minority men, right? That's the idea. It's not a direct harm, it's just a perceived stereotype or generalization that those things happen. So we're talking a lot about how do they prove it, right? Or what can you ask for, what can't you ask for? A provider, a housing provider, a city official, whoever is processing the reasonable accommodation can only obtain information that is necessary, and again, necessary is a subjective term, but necessary to evaluate if a requested reasonable accommodation may be necessary. And this is only if it's not readily apparent, right? So I can see if somebody is visually impaired, right? Or if somebody's walking with a cane. I can see if somebody is in a wheelchair, has some other mobility device. That is readily apparent. That I can see. You should know by then. You shouldn't be requesting information. Or if somebody calls on a TTY, or somebody has requesting a hearing auxiliary aid, that should be enough to know that that person suffers from a disability. If you know, a lot of housing providers, if you know the source of income of an individual, and you know that their only source of income is disability income, then you should know that they are disabled, right? So that's readily apparent. Those are things that you can deduct and understand from seeing the person or from interaction with the person. It's readily apparent. You shouldn't be asking for additional documentation, right? If it's not readily apparent, so it's something that you can't see or something that isn't easily accessible to you, you can't make out why the person needs 9 dogs or why the person needs 11 cats. That doesn't make any sense to you. The person doesn't exhibit any type of need, right? There are times where people have mental disabilities that aren't always apparent. Then you can ask for a reliable third party who knows about the individual's disability. Now, a lot of the times what we'll see these documents that get sent to third-party verifications that get sent to the person's doctor. It gets faxed directly to the person's doctor. It does not have to be a person's physician. And that should and those requests should just be that you are requesting information on why they need the accommodation and what the connection is between their disability and the connection. Right? So for example, I need an animal because the animal helps me get up and go to work every day. That's sufficient. Asking when the physician started treating the person, asking how severe the person is, asking if the person can get another animal instead of the animal that they have is not. That's actually things you are not allowed to ask. So those are things that are illegal. So a provider can deny a request for reasonable accommodation. Again, I understand that there are there are issues, right? There are issues that that can't always be addressed by always following, following these to a T. So when a provider can deny the request is, actually I like to think of it as 3 reasons. By law, there's 2, right? It imposes an undue financial and administrative burden on the housing provider. And 2, fundamentally alters the nature of the provider's program, which we spoke about earlier about the waiting list example. And 3, like an actual threat, like a direct threat or harm to the community or to the individuals around. That's what I like to think as well. Determination should be on a case-by-case basis, right? There's always a gray area. Attorneys, whether by trade or, actually everybody, I think, like as humans, there's always a gray area. Or like, there's always like, right, the truth, like there's always 3 parts, right? The truth, right? The truth, the lie, and then, or like one side, side A, side B, and then the actual truth, right? There's always this like gray area. No one ever likes to own up to things. So determine everything on a case-by-case basis. Everything's subjective. You must explore the availability of alternative. A lot of the times we will see cases where housing providers or county, city officials will go forth and say, well, that's unreasonable for us to do. We can't do that. It's going to change our program, or it's going to cost us too much to make this accommodation. But we can do ABC to better serve you. That's what we can do. That's within our privy. That's not going to actually have an administrative burden. That's not going to cost us a lot of money. We're more than happy to conduct this accommodation. And I've seen people deny it and file complaints. And I've seen those complaints go to HUD, and HUD is like, they did what they were supposed to do, right? So the idea is that you must actually provide alternatives that will meet their needs. All right, housing providers cannot require persons with disabilities to pay extra fees or deposits, which we talked about in regards to different like pet fees or charging them to put in ramps or modifications, those kinds of things. Any questions on reasonable accommodations? Granting reasonable accommodations? So Fair Housing Act accessibility, right? The Fair Housing Act requires that new covered multifamily housing occupied after March 13th, 1991 follows 7 design and construction requirements. Those 7 are an accessible entrance and an accessible route. We talked about the sidewalks earlier, making sure that the sidewalk from the parking lot to the ramp is actually accessible. Accessible public and common use areas. So anything outside mailboxes, in rental properties, your pool space, in public spaces, your parks and recreational areas. Usable doors, accessible route into and through the dwelling unit. Accessible light switches, electrical outlets, thermostats, and environmental controls. Reinforced walls into the bathroom. We had a discussion about this. It's not absolutely necessary that you install grab bars in all of the bathrooms in housing dwellings. However, you do have to reinforce the walls to make sure that people can install grab bars if they wish to in the future. And then usable kitchens and bathrooms. So fair housing, zoning, and land use. The Fair Housing Act states a dwelling includes any vacant land which is offered for sale or lease. For the construction, so any residential zoning, for the construction, you have a lot of new apartment buildings, townhouses. In metropolitan cities, we're seeing a lot of high-rises, right? Those decisions cannot be related to the development of such land where the land is being developed for certain residential zoning based on race, sex, religion, national origin, color, disability, or familial status. Municipalities cannot make zoning or land use decision based on neighbors' fears, right? So we hear about NIMBYism, not in my backyard. A lot of the times we'll see that happen where individuals will come to come to town hall meetings, come to city official meetings, and say, well, we don't want that group home there, or we don't want, we don't want that construction going there, affordable housing, because what's going to come with affordable housing is minorities and problems, right? So that's illegal. If you're making those decisions, even though it may be that there are community members that are coming, that those decisions cannot be made regardless of a NIMBYism effect or of the community's effect, because those decisions are being made based on race, color, national origin, religion, disability, or familial status. So zoning ordinances may not contain provisions that treat users of individuals such as affordable housing, supportive housing, group homes for people with disabilities any different than normal individuals. Municipalities cannot enforce ordinance more strictly against housing occupancy by members of protected classes, so the enforcement of it, right? So if you're always going to a certain part of the city or a certain county, and you're always enforcing it there when a code enforcement is called, but you're never going to maybe a more affluent neighborhood, and you're actually not going to address those or look into those violations, that can be seen as a fair housing violation as well. Discrimination in zoning and land use also includes if something is facially neutral. So anything that does not have the intention of discriminating but has the impact of discrimination. There was a case in Texas that actually you saw this. The individuals did not have any intention of discriminating, but once the zoning ordinance was passed, it actually eliminated housing for people of color. And that went all the way to the Supreme Court, and the Supreme Court found that they had standing. Prohibiting or restricting the development of housing based on the belief that the residents will be of a protected class. So again, NIMBYism. This happens a lot with affordable housing, where they think that the people that move into affordable housing are minorities. Imposing restrictions or additional conditions on group housing for persons with disabilities that may not be imposed on other families or other housing in your city or your county. And then imposing restrictions on housing because of alleged public safety concerns. So when we're talking about the majority, we're making stereotypes, generalizing, say, well, this is going to be an issue for others in the community, right? That's actually illegal. Imposing restrictions based on the alleged public safety concerns when there really hasn't been any direct harm or threat. Zoning and land use prohibited practices, enforcing otherwise neutral laws or policies differently. So we talked about, the ordinances are there, but we only actually go out to code enforcement calls when they're in a particular neighborhood. Refusing to provide reasonable accommodation to land use or zoning policies. We saw that in the consent decree with the 1,000 foot rule. So refusing to provide reasonable accommodations to allow persons with disabilities to have an equal opportunity to use and enjoy housing. So we're going to talk about your role in ensuring fair housing. I do want to show this is my last quick video. This one's a little bit longer, but just to talk about recovery and defining recovery and the importance of individuals being integrated and understanding their contribution to society, because I think that that's a lot of the times where people get caught up in understanding and treating people that have this substance abuse. It's consistently a stereotype of, well, you did this to yourself, or you can change this. Why are we addressing this as a disability? And so I think that this video does a good job about redefining it and understanding it for future success in affirmatively furthering fair housing and making sure that you're addressing violations before they occur. So one is fair housing training, right? This is mandatory, but you should be having fair housing training annually. You should be looking at conducting fair housing training that is specific to topics that you're seeing, right? If you're seeing issues with ADA compliance, having issues with reasonable accommodations, making sure that you're looking at different ways to be trained, so webinars, going to conferences, making sure that your staff, when they're first brought on, receives fair housing training. I know that this training is going to be available as a recording, so making sure that your staff isn't waiting a whole year to get the next training, right? They're getting it within the first 30, 60, 90 days of actually starting their employment at the city. Keeping up-to-date resources, right? So different books, different articles, there's constantly new development around fair housing. There's cases being brought all the time which will let us interpret and understand these laws better. And then continuing to look for opportunities to gain knowledge. The reasonable accommodation policy, it's currently being reviewed by the DOJ is my understanding, but you should be specifying that you provide the reasonable accommodations, making sure that you're sticking to time frames, providing contact information for the individual that is going to take fair housing complaints for your fair housing compliance officer. And then also consider proposing temporary accommodations. So if it's going to be a subjective gray area, maybe you provide an accommodation at the moment and then revisit it when the investigation has completed and you've considered all of the facts. Requiring that all information received be confidential, and then also explaining the complaint process and explaining how fair housing complaints work, providing everybody the opportunity to actually submit a fair housing complaint because you want to be able to address it. It's my understanding that you all have a fair housing organization locally that can address those issues. You have a fair housing organization locally that can come forth and provide the training and mitigate any type of complaint that's going to be coming out, explaining to all of your staff the consequences of violating not only your reasonable accommodation policy, but also the Fair Housing Act, the ADA, understanding that there's real consequences, and that's not only the consent decree and the DOJ coming in and the money that's paid out, right? Those are things that we think of, but the real consequences of the individuals and the impact on their lives and their housing. I'm sure no one here ever wants to be evicted from their home or lose their home because that's your domain, that's your access to opportunity, it's your access to education. Really, that's the stability of it all. So understanding not only the cost to the city monetarily, but really like the impact on those individuals. Fair Housing Compliance Officer, this was part of the consent decree that a Fair Housing Compliance Officer be appointed. Vanessa stated earlier, Ms. Loretta Johnson's going to be the Fair Housing Compliance Officer, so if you have any questions, contact her, contact me. Her and I have been talking for months, so I'm sure we'll remain in contact if she has any specific questions. Again, don't be scared to ask a question that may come up because you want to make sure you're mitigating and being proactive in dealing with these before it comes up to a larger degree and a larger standard of scrutiny. Community engagement, right? So identifying the issue and who it impacts. A lot of the times we think about the majority, we think about the majority population. So we think about, oh, it's going to impact families or it's going to impact this group of individuals. No, think about everyone that it's impacting, even the little guy, even the small minority population, the community as a whole. Creating equal power, right? So including language where you're not speaking at individuals, but you're speaking to them and you're including their wants and needs and their concerns. Acknowledging the history of the community and understanding the frustrations of the community, and they're going to be different for all the individuals in those communities. And sometimes they do collide and sometimes they aren't the same. So there will be some friction and there will be some misunderstandings, but as long as you're sustaining conversations and understanding and giving everybody an opportunity to speak, that's really how you engage, create dialogue, and create real change and understand. And remembering community leaders are not substitutes for community members. There are community leaders that are elected because only 10% of voter turnout came out, right? Or community leaders that were voted in and because of certain term limitations are continuously in those positions. So they are not substitute for community members. They're there to work for the community, and the community should be engaged. And making sure that the community is engaged through not only resources that are invested in the community, but different meetings. So diversifying your meetings. If you need to have them in places like churches, if you need to have them in different town halls, if people don't want to come to town halls, or maybe people aren't religious, so they don't want to come to churches, making sure you're diversifying and reaching out to everybody. If you have a community that is limited English proficient, right, are you reaching out to that community? Does the community speak Spanish? Does it speak French? does it speak Creole, making sure that you're getting those resources out to include them in the discussion. Because what happens is when you exclude and omit people from these discussions, that's really when you come up with different laws, regulations that do not impact everybody fairly, right? Creating clear accountability and sharing your outcomes, sharing your outcomes with each other, right? Where do you want to be? What are the main concerns? If the concern is, protection for predatory practices that may happen to group homes or homes with persons with disabilities, if that is going to be an issue, where do you want to be? What do you want? What outcome do you want? Right? So not looking at the bigger picture, but coming down and making small incremental changes, right? So we want to address and make sure that people aren't, taking advantage of consumers because there's going to be, a predatory service and they're not going to actually be provided the service, right? So looking at small incremental changes and then larger, where do you see your city in 5 years? Where do you see your city in 10 years? And making those changes now, because small changes are really what's gonna cause there to be a real change. Otherwise, you're gonna be constantly battling years and years of bad practices, right? So thinking small things. And the process is never over, right? That doesn't mean that I want to come back because there's going to be another consent decree. That's not what I want. The process is never over in the sense of you all as community members, you all as city officials, if you're employed with the city, just as members of the city of Jackson, as residents, it's not over. It's not over when you retire. It's not over when you leave your post as a community leader, right, or as an elected official. It continues, and the process is usually long, and we haven't figured it out yet, right, because I wouldn't have a job if we had. So with that, this is my information. You're more than welcome to email me, call me. I'm usually readily available to everybody via email. I'm not in the office a lot, so sometimes it'll take me a while to get back to you, get back to your call, but I'm pretty quick about answering emails. Does anybody have any other questions? Yeah, so that's it for me. We are gonna have a 2 p.m., so if anybody's missed it that make sure they come. Thank you.